occupied territories of the Musqueam, Squamish, and Tsleil-Waututh people in what is now called Vancouver. I'm wearing a mask because I have a little bit of a sore throat, so it's a little bit of a blast from the past right now. But just as a precaution, I don't want to spread germs around. And I'm very pleased to welcome everybody in the room and online to the latest of the Center for Law and the Environment's public talks in our no-fly zone series, which allows us to hear from leading practitioners and thinkers of law and the environment without incurring or creating travel-related greenhouse gas emissions. It's just a fancy way of saying that this is a webinar. But in any event, we're really pleased to welcome Kaitlyn Mitchell, who is the Director of Legal Advocacy at Animal Justice, to speak on the topic of ag-gag laws and the Canadian Charter of Rights and Freedoms, the fight against laws to keep farmed animal suffering and abuse hidden from public view. I'll just introduce Kaitlyn briefly. But before I do that, just a note, since this is a hybrid event, some folks in the room and some folks online, we will have a kind of a hybrid approach to questions and discussion. So after Kaitlyn is finished presenting to us, there will be a Q&A period. Folks in the room will be able to simply raise their hand and be recognized. Folks online, same thing. If you want to ask a question, just use the raise hand feature and I should be able to figure out how to unmute you and allow you to speak. And I think that's the logistical, the only logistical note that I needed to give. So Kaitlyn is the Director of Legal Advocacy, as I said, at Animal Justice, Canada's leading national animal law organization, which she joined in 2019. Since then, she has worked to strengthen animal protection laws at all levels of government, including a successful advocacy for a new federal law to phase out toxicity testing on animals and a Canada-wide ban on the use of strychnine to kill wolves, coyotes, bears, and other animals. Kaitlyn represented Animal Justice in its successful constitutional challenge to Ontario's agricultural gag or ag-gag law, which she will talk to us about today, and has appeared before numerous courts across the country, including the Supreme Court of Canada. Before joining Animal Justice, Kaitlyn worked as a public interest environmental lawyer for over a decade. And if my memory serves, that was with organizations including Greenpeace International, or maybe Greenpeace Canada, you can clarify, and Eco-Justice. Focusing on development and enforcement of environmental rights and advocating for communities impacted by environmental racism. Kaitlyn graduated from Dalhousie Law School in 2007 with a certificate of specialization in environmental law, and before that, an undergraduate degree from the University of Winnipeg. Thanks so much for joining us, Kaitlyn. We're really looking forward to hearing what you have to tell us about ag-gag laws and the charter. Over to you.
Great. Well, thank you so much for having me. I'm always excited to talk about this subject. So agricultural gag or ag-gag law, they have a long history in the United States, but they're a bit newer in Canada. So they are, I find, a topic that not everyone is aware of, at least yet. So in the United States in the 90s and early 2000s, there was an increasing number of investigations or exposés showing the treatment of animals on farms. So in the United States, there was this pattern in the 90s and early 2000s where folks would often get a job at a facility, record what was happening, and then release that footage publicly. But while this is a bit of a more modern trend involving, hidden camera footage, the practice of going undercover at agriculture facilities and really other facilities is one that goes back a long time. In the United States in 1906, Upton Sinclair was a journalist, and he went undercover in Chicago's meatpacking district and uncovered what was really startling food safety practices that really led to the advent of modern public health and safety laws in the United States related to the meat industry. So this is a practice that has a long history, but we started to see in the 90s and 2000s that this was making the news, and the footage really didn't make industry look great, to say the very least. There was some really shocking footage released about abuse of farmed animals, but the footage also showed suffering caused by really standard practices. So, let the public see what gestation crates look like, what battery cages for hens look like, and so forth. And in response, what we saw in the United States was that legislators reacted. They did not, however, react by passing stronger laws to protect animals. Instead, in many states, legislators reacted by passing stronger laws to prevent the release of undercover footage. So this is what we call agricultural gag or ag gag laws. They're designed in whole or in part to restrict this ability to gather footage and release it publicly. And in the United States, they've taken a number of forms. Sometimes they prohibit recording, for instance, but commonly what we've seen is these laws prohibit entry under false pretenses. And that's the term that we will see shortly has been adopted in Canada, including in Ontario. So here's a map from the United States. It's actually possible there have been a few more challenges since this map was created, but it shows the states where there have been agricultural gag laws attempted, states where they've been passed, and then the bright red ones are the states where they've actually been struck down as unconstitutional. So much of the litigation in the United States has been successful. 6 courts or more at this point have found that agricultural gag laws are unconstitutional violations of the First Amendment right to free speech. Now, we don't have a First Amendment right to free speech in Canada, but what we do have is a charter right to free expression, which is in many ways quite similar. So like the United States, the industrialized agriculture industry is alive and well in Canada. We raise and slaughter more than 830 million land animals each year for food. That number is going up as people increasingly eat smaller animals like chickens. We tend to think, and I actually apparently in last night's Liberal leadership debate, this came up as well, this notion that in Canada we don't have factory farms. Our system is much different. But unfortunately, that's not the case. Most of the animals slaughtered for food in Canada are raised indoors in tightly confined conditions, which are common in the United States as well, and what are commonly referred to as factory farms. And the number of animals slaughtered, here the chart shows about 830 million. That doesn't include, fishes and other marine animals slaughtered for food. It doesn't include animals farmed for fur, like mink and foxes. It doesn't include millions of male chicks slaughtered each year at egg facilities. So it's a really staggering number of individual lives. And from a legal standpoint, there are laws in Canada, federal laws primarily, governing the slaughter of animals and also governing the transport of animals. Unfortunately, our transport laws in particular are among the worst in the Western world. We allow animals to be transported vast distances without food, water, and rest, but we have some laws. But in comparison, we do not generally have laws that govern the treatment of animals while they are on farms. So while they are being slaughtered, there are legal standards. While they're being transported, there are legal standards. But for the most part, when they're on farms, there are no legally enforceable standards. We have animal protection laws that prohibit causing distress to animals. But those laws, including BC's Prevention of Cruelty to Animals Act, generally exempt distress that's caused in accordance with, quote, generally accepted and reasonable practices. So when it comes to what is a generally accepted practice, governments and industry tend to point to non-binding codes of practice that are developed by the National Farm Animal Care Council, which is a non-governmental body made up predominantly of industry. And there are no publicly enforceable laws on these facilities. And again, generally, inspections tend to occur only when there's been a complaint. So if someone's reported that they think that they've seen some sort of abuse or neglect, that's when authorities would enter a facility. But again, most animals are being raised indoors on private property. And so there's no members of the public present to observe what's happening. So it's really workers and the owners and operators of these facilities who tend to see what's going on. So when this trend started in the United States and we saw agricultural gag laws being introduced, there were some studies that have happened that have shown that the notion, once the public learns of the fact that there are ag gag laws on the book, it actually decreases public confidence in the industry because folks start to wonder, what is there to hide? Why are they passing these laws? And so originally in Canada, and this is what this article shows, originally here the industry said that they did not want ag gag laws here. They said in Canada, we want to keep the barn doors open, not closed, so there's no place for agricultural gag laws in Canada. But then the industry's position changed. It's unclear why it changed, but it seems that there were three main factors. The first is that the expose started here. The animal protection community here started to release footage, often covertly obtained footage from inside facilities, showing similarly horrific suffering as what was shown in the United States. So again, there's sort of two categories, if you look at it that way. Much of these exposés showed horrific abuse, which, is staggering, really, a lot of it. And unfortunately, I've seen most of it at this point. But it also showed just standard practices and the types of harm that can be caused by standard practices, like confining pigs in gestation crates, grinding male chicks alive on their first day of life, and so on. And, the exposés were making headlines. They appeared on shows like W5, CBC Marketplace, and several actually led to convictions against companies involved and workers involved. And many companies, as a result, committed to taking action on their own and changing their practices. And a second trend that started was around 2010, the Animal Save movement started, which is a group of organizations across the country. It started with one, and the founder is pictured here, Anita Krines, who started protesting outside of slaughterhouses and holding vigils. So they approached trucks. At some facilities, they do stop the trucks. At other facilities, they just observe trucks. They witness the condition of the animals inside. At times when they've shared footage with me as a lawyer, I've used that footage to file legal complaints showing that the transport laws that we do have are not being followed. And some individuals, as you can see here, Anita, started giving animals water on extremely hot days when they were waiting outside of slaughterhouses. Anita was, I should mention, charged with criminal offenses for giving animals water, but she was acquitted after a very long and public trial. And then the third trend that we saw in Canada starting in the kind of mid-2010s was some civil disobedience. And this is probably the most well-known instance, which you might be familiar with because it was in BC. But we started to see a few instances where activists were staging essentially these peaceful sit-ins at facilities. And so this is absolutely a form of civil disobedience. Everybody knows that trespassing is illegal. And in virtually all cases, the individuals involved were charged because we have already trespassing laws on the book. And then there was a sit-in in Alberta, and the government responded quite quickly. So this is at a turkey farm in Alberta. The folks involved were charged because we have laws to make it illegal to trespass on private property. But it got the government's attention, got the industry's attention, and quickly we saw the Alberta government say, we need stronger laws to protect against these activists. So again, the public rhetoric was very much focused on trespass, which is illegal, absolutely, already illegal. So the public rhetoric really made it sound like what the government was doing was increasing trespassing fines, which is something that governments can do. There's really no argument there. That's not unconstitutional. But what we saw when the laws were actually introduced and when industry started lobbying, so groups like Maple Leaf Foods and other companies and industry bodies started lobbying governments for this law. And although the public rhetoric was very much focused on trespassing, what we saw was that actually the laws contained these American-style ag-gag provisions that focus not only on trespassing incidents and just increasing fines for that, but basically turning undercover employees also into trespassers. So these laws, at least in Alberta and Ontario, really focus on preventing undercover exposés. Manitoba, where I live, also has an ag-gag law, but it focuses only on the interaction or interference with animals in a transport vehicle, so sort of a separate issue, and Ontario's and Alberta's laws also target that activity. So these laws, on the whole, target all three of the sort of trends that I mentioned. Increase fines for trespass, that's something that governments can do, but then restrict peaceful protest rights and restrict the gathering and dissemination of footage. So really quickly, within, I think, less than a month of that trespass incident happening, Alberta passed the first Canadian ag-gag law, and it contains this false pretenses language that we saw in the United States. So prohibiting entry under any property, actually, Alberta's law is quite broad, under false pretenses, no exception for journalists, no exceptions at all. And that was passed incredibly quickly after that incident. And shortly after that, we saw Ontario follow suit. So they introduced the Security from Trespass and Protecting Food Safety Law, a very, very long title. And it passed at the start of the pandemic, actually. And it contains very similar language to prevent trespass, but also to prevent entry under false pretenses. And it's that false pretenses language that was the focus of our legal challenge. So, we're a legal organization. Animal Justice doesn't engage in trespass activities. That's not what our lawsuit was about. But of course, a lot of the government's response to our case really did focus on those trespass incidents being the justification. So similarly to Alberta's law, this false pretenses language is in there. And the way that Ontario's law works is it focuses on creating what is called an animal protection zone. So an animal protection zone under the ag-gag law includes the floor of the slaughterhouse where animals are killed. It includes a rodeo ring. It includes a horse racetrack, petting zoos. Basically, anywhere where farmed animals are being kept, no matter what's being done to them, is an animal protection zone. Interestingly, sanctuaries that actually care for farmed animals are excluded from the law, so those don't count as an animal protection zone. So if you enter an animal protection zone under false pretenses, you can be charged with an offense, and the statute also prohibits interacting with farmed animals while they're in transport. The law is backed up by some pretty stiff penalties, not actually quite as high as Alberta's, but high. Up to $25,000, I think, for a second offense. And it also contains some pretty sweeping citizens arrest provisions. And it also includes some interesting language around allowing the owners and operators of facilities to question individuals, and then it's an offense not to give them your correct name and address, which again is fairly unprecedented in Canadian law. So we challenged that law in court, and it wasn't just me. We were working with Arden Beddoes, who is a Vancouver-based lawyer at McEwen Partners, as well as Stockwoods in Ontario. So there was a team of us. We challenged this law, and this is a picture of the protest outside of the courthouse while we were arguing on the first day. So our challenge focused on the Canadian Charter of Rights and Freedoms and the right to free expression that we all have. And we argued that the false pretenses provision in particular violates our right to free expression, and not just our rights, but the rights of any individuals who want to express themselves, observe what's happening, release footage, and also violates the corresponding rights of the public to receive crucial information that can inform food purchasing choices. So the full text of the section's up here, and I don't think you need to read all of it, but basically it says, if you've entered a facility, then and your consent to enter was obtained under false pretenses in the prescribed circumstances, so I'll explain that, then you don't have consent after all, and you're a trespasser, is basically what this section says in a nutshell. So what is in the prescribed circumstances? Well, the regulations set out, there are regulations passed under the law to explain, well, when is it illegal to make a false statement and when is it not illegal to make a false statement? So our challenge really focused on the wording in these regulations. And, for anyone that's familiar with the test for free expression in Canada, really, the focus is, is there expression here that's intended to convey meaning? And we said that, first, making the statement itself is a form of expression. So, we're not talking about lying, saying, I am a veterinarian and I have some sort of expertise to do, really particular procedures on animals. That's not at all what our case was about. It's more about individuals who get hired at a facility and they might be asked, do you have any affiliation with an animal protection group? That actually does happen. They're asked outright and they say no. That's a false statement. Does that false statement on its own cause any harm to biosecurity or animal safety or any of these other things that the Act says it's about? Well, no, of course it doesn't, but that is expression. And it's not just that expression on its own. That expression is made specifically in order to see what's happening inside facilities and, obtain evidence that can then be used to promote social dialogue. So we said this is exactly the type of expression that really lies at the heart of Section 2B of the Charter. So again, you do not need to read all of the text on this slide, but this is the section in the regulation that says, okay, well, what is a false statement? What is illegal here? And it's about as broad as it gets. It says, if you make any false statement orally or in writing for the purpose of getting consent, and then you get that consent, that's a false pretense. And that's illegal. That's what the Act is targeting. So incredibly broad. I've been focused so much on undercover exposés, and certainly I think that was the target of the statute, and that's what the evidence in our case showed. But I should also flag this is so broad that it actually just captures a range of, super trivial and ridiculous false statements. So, if I was entering a petting zoo and was asked, do you have a camera in your backpack? And I said, no. And even unintentionally, quite frankly, because it doesn't really get into whether the lie has to be intentional, that would fall under this. Or, lying to get closer to a rodeo ring. So the net cast is really just so broad that it's difficult to really think through all the scenarios that could be captured. Now, the one thing about Ontario's law that's a little different than Alberta's is that they actually did create two exceptions. One is for journalists and one is for whistleblowers. Presumably that was done in an effort to try to make the law survive a constitutional challenge, but in our case, we were successful in showing that those two exemptions were actually completely useless. They contain a number, and they're very, very long. They're like these itemized lists that a journalist or an employee has to meet to be exempt from the law. But basically, journalists are defined very narrowly, and the law basically said that if you're, a journalist or a whistleblower and you've caused any harm to a farmed animal, not just illegal, any harm, and, as we know, working on the floor of a slaughterhouse, you're going to be killing animals, working entry-level jobs at facilities, you're likely to have to mutilate them, cutting off the tails of piglets, and in any number of standard practices. So if you harm an animal, you're out. You don't get this exception. And for whistleblowers, you have to actually obtain illegal or footage of an illegal activity. So getting that footage that I mentioned that just shows what life in a battery cage looks like, not enough. You have to get actual footage of an illegal activity, and you have to immediately give it to authorities. So you can't document a pattern of abuse at a facility, for instance. So those are just two ways that these exceptions were, that we argued and the court agreed. These exceptions were so narrow that they were basically unworkable. There's no way to know going in, you're for sure going to get footage of illegal activity. You're not going to get caught before you then are able to give it to the authorities. And, as many of you might know, folks that work again, like we can talk about activists, but it also applies to all workers. Many folks that work at agricultural facilities and entry-level positions might have very good reason for not wanting to talk to legal authorities. Their employment status could be impacted if they rat out their employer. Their status living in Canada could actually be impacted. But this law says you have to go straight to authorities. So thankfully, the court agreed with us, as I'll mention in a minute, and struck out key provisions of that regulation. We also challenged the provisions that make it an offense to interact with farmed animals. We didn't win, so I won't focus on those. I'm happy to explain why we didn't win those, but basically it's because the government had kind of narrowed the prohibition a little bit in the regulation and defined interaction in a way that limited it to a specific type of activity. So basically physical interaction, whereas in other provinces like Alberta and Manitoba, it prohibits any interaction. And I honestly don't know what that is. I often go to the airport, for instance, when they're exporting horses for slaughter, and I have no idea at what point I could be found to have interacted with a horse in a truck. So Ontario's law is a little bit more constrained in that way than Manitoba's or Alberta's. So as I mentioned, we were successful in our challenge, which we are very excited about. So this is the first challenge to Canadian agricultural gag law, but it won't be the last. Spoiler alert, I'm confident that the other ones will also be challenged, whether by us or by other groups. But the court agreed that, what we were talking about here was expression. That's important. It's about truth seeking. It's about participation in democracy and in social debate. And the court agreed that while some sections of the law might have to do with legitimate objectives like biosecurity, protecting food safety, the false pretenses provisions did not. They went way beyond that and captured, the type of speech that I mentioned earlier that really causes no harm to animals and in fact can benefit animals. It can also benefit the environment. One of the groups that sought leave to intervene in the appeal is an environmental group because in addition to exposing, workplace safety violations, animal cruelty, sometimes undercover footage has exposed environmental harms as well. As we know, there's massive sewage lagoons at many of these facilities and many other practices that really do present a risk to the environment. So the court agreed with us that the law impacts that type of speech and that type of speech is not related to valid objectives like biosecurity or protecting food safety. And so the court struck down Section 9, which is that part of the regulation that says, any false statement that's illegal. But it also struck down some of the sections in Section 11 and 12, which are the two exceptions for journalists and for whistleblowers. And basically said that because of how detailed these lists are, they constrain speech. And again, it's not being done in furtherance of these legitimate objectives. It seems to be being done to prevent expression that is harmful to industry. And that's not a valid reason to restrict the right to free expression. Since we launched our challenge, the government has now gone ahead and amended the regulations. So the fight continues. The government's appealing our victory, which is not surprising. That appeal will be heard at the end of June, and now we have this added uncertainty because they've made changes to the regulation, some of which do actually address the problems that the court identified, but several of which actually don't address them at all. And in some ways, they make them worse. So the battle will certainly continue for a while in Ontario, and as I said, presumably in other provinces as well. So I will wrap it up there so that we have some time for questions before the end of the session. But my email address is here, kmitchell@animaljustice.ca, and you're welcome to reach out to me anytime. So thank you very much.
Thank you very much, Kaitlyn. There was so much in that, and it really also felt like you barely scratched the surface of that court decision. I want to open it up for questions, but as I do, I was wondering if you could just share maybe one thing that you found was particularly hopeful, or one aspect of bringing and winning this case in first instance. What stood out to you the most in terms of reason for hope, or something to really celebrate?
Yeah, that's a great question. I mean, obviously, we were just thrilled with the result. But, I think that, I don't want to be overly confident, but I think that the case law was on our side. So it wasn't, shocking. And as I've said, these laws have been struck down in the United States. But I think the part of the reasons that really jumped out at me and made me feel like, the court had understood the issues. If you read the decision, Justice Conan starts by talking about these contextual factors. So he basically goes through and kind of shuts down a lot of the rhetoric that industry put forward in the case and the government put forward in our case. There's this, the industry was saying like, these are, family farms and, the animals are treated so well. And we have so much oversight because we have these industry programs. I think that Justice Conan did a really good job at really looking at the evidence. And so he said, he recognized that Canada's animal agriculture system is increasingly industrialized. He recognized that, as I said, there are no laws that are protecting the welfare of these animals on farms. It's not his place to say whether there should be, but, he went through and kind of explained why groups like ours might see that as problematic, that industry is making up its own rules. And he talked about this complexity around, when you don't have a legal standard, but you're pointing to industry standards. And he gave a really good example where he said, basically, this is a really complicated thing. You can't expect workers to always know what is and is not legal. So he said, and I'm paraphrasing, but he said, after 3 days of legal arguments, I heard a lot about this practice of thumping, which is where you take a piglet, and you swing them by their back legs, and you hit their leg or their head hard against a hard surface to euthanize them. And he was like, I don't know, after 3 days of arguments, I don't really understand if that's legal or not. I know that it's okay in the codes, but then in practice, I've seen all this footage of folks doing it and they're bashing the piglets over and over again. So he was like, he basically said, this is really complicated, and I can see why groups like this want to communicate about it and why the public might be interested to see this type of thing. So to me, that was really exciting that he understood the importance of these issues, as well as the real context within which this expression is taking place.
Yeah, and that gray area between what's legal and what's illegal was also an important part of his reasoning about the constitutionality, especially around the journalism and whistleblower exceptions, because anytime someone who's doing one of these undercover investigations observes something, they have to make a decision on the fly that is correct, basically about whether this activity is legal or illegal. Basically, it's a Russian roulette that, in terms of whether they will be, whether they will now be doing something illegal or not.
Yeah. Yeah, and if you're wrong, then you can be charged because that
Yeah.
that means that what you did was illegal in the end. So yeah, it's a huge risk, and the chilling effect is really staggering.
What would you say then on the other side? What would you say you were most disappointed about in the decision, or anything else about the case in terms of, still challenges to overcome?
Yeah, I mean, I skirted over the part that we lost, but that was disappointing. I feel less disappointed because I think that there's still a clear challenge to be made to the other provinces' laws that restrict interaction with animals. But I did find that part disappointing because, while it's narrowed a bit and kind of focuses on prohibiting physical contact, without getting into the nuance, it is still a bit broader than that. And so I do think that the law is impacting peaceful protest rights. I'm hoping that because of the way that the decision was worded, that, you know, if an individual, let's say, was charged with interaction, that in the future there still could be a challenge. And maybe that's the type of case where it would be stronger to make that challenge based on a clear factual record showing, what kind of protest activities were targeted here. So, yeah, so I was definitely disappointed with that, but tried to kind of temper my disappointment by thinking, okay, well, there's still a path here in Ontario to challenge the law, and I think still Manitoba's and Alberta's laws are so vague in that regard in terms of what is interaction that our loss in Ontario at least won't cut off the opportunity of challenging those two laws.
So in terms of the interaction, the type of interaction that has gotten the most sort of publicity and that we see, from groups like Toronto Pig Save, is simply this act of bearing witness when the transport trucks, are waiting to pull into the slaughter facility. And for example, speaking to the animals or offering them water. One thing that really struck me in the decision was how quickly the judge simply endorsed, or how unquestioningly, the basic assumption that these animals are objects, they're property, and what the people like Pig Save are trying to do is they're trying to use someone else's private property as the means of their expression, and you can't do that. So to me, that sounded like well, that would have been an opportunity to start to crack open that little sort of aspect of Canadian law around animals.
Yeah. Yeah, it was really disappointing. And I think he used the word, like, I'm trying to remember the exact quote, but basically that it's not, you can't use Section 2B to appropriate someone else's property, which is true, but that's not what, we were trying to do. And I think I actually forgot to mention that our co-applicants, it wasn't just Animal Justice that challenged it. We also challenged it with Jessica Scott Reed, who's a journalist, and Louise Jorgensen, who organizes cow save demonstrations at a facility, a slaughterhouse facility in Toronto. And Louise isn't out there, appropriating anybody's property. She's standing there day in and day out. She's observing cows in their final moments. She offers them kindness. She takes photographs of them, which are absolutely heartbreaking, I can say, in many ways. She's taken photos of there's down cows in trucks being stepped on by terrified living cows. There are wounded cows, there are lactating cows, they have open wounds, there's cows that have, icicles forming on their chins. So yeah, allowing Louise to capture those images, and she doesn't stop trucks. She doesn't do anything that would be illegal under any other statute. She's just there very peacefully and respectfully. I can see that capturing those images makes the industry look pretty bad, and it lets people like me submit complaints to law enforcement authorities, but does it cause any other harm? Does it mean she's appropriating anyone's property? I would say not. So So yeah, I was it was very disappointing, and it was a really challenging decision on our part whether or not to cross appeal, but we didn't.
Okay, so the actual quote you were referring to is in paragraph 202 of the decision, and it says, um, the protection the applicants seek is to interact with animals. In other words, the applicants want to use physical contact with the private property of another person as a means to their self-fulfillment. And then skipping down to the end of the paragraph, it does not allow people to appropriate even momentarily the property of others as a means for expression. Sorry, the freedom of expression does not allow people to appropriate even momentarily the property of others as a means for that expression. So yeah, that's how he characterizes what's happening with those interactions. I should see if anyone else has any questions, and it looks like there are, so just introduce yourself by name.
Hi, I'm Elise. I'm also a fellow University of Winnipeg grad. So, hello. I was wondering why, if there was a particular reason why you chose to challenge the Ontario legislation as opposed to Manitoba or Alberta, and whether you've seen any response from the other provinces following this decision.
So our decision to go with Ontario first, um, there were a number of factors. Like, we were heavily engaged in the passing of that bill. We were advocating against it. There was a really good, I think, record there about why that law was problematic, why it was unconstitutional. There were some differences in the courts in Alberta and Ontario, just in terms of, potential receptiveness, perhaps, to some of our arguments. So there were just kind of a range of reasons that we decided to challenge Ontario's first. The other thing about Manitoba's, and you're from Winnipeg, so you probably know, we have a new government since that law was passed, and the opposition NDP, who's now the government NDP, they were very, very strenuously opposed to Manitoba's ag gag law when it was passed. They were very forceful and very clear that this was unconstitutional, that it violates free expression. And so I'm hoping that we'll never have to challenge Manitoba's. I have, since that government came into force, reached out numerous times, and they have not moved as quickly as one might hope. That I'm so hopeful. I know that there's a lot, going on. There's many priorities. There are many reasons that, governments, especially in Manitoba, might want to be careful about upsetting rural interests. So, I appreciate that it's still complicated. But, I'm hopeful that in Manitoba we'll never have to get there and go to a lawsuit, and that the government will do the right thing. They don't have to repeal the entire law. They could just repeal the really problematic language, which is just around interaction with animals. And, I think stay tuned for Alberta. Hopefully there will be a challenge to Alberta's law in the not too distant future.
Thank you.
Another question? Okay, yeah, so Quinn, question from Quinn, and then I just had one last one, and I think then we'll wrap up.
Hi, I'm Quinn. I'm curious a little bit, I think you kind of touched on it, but I'm curious what your thoughts are on the potential for recognition of animal rights kind of outside of like the human anthropocentric ones, and similar to like legal personhood and rights of nature, and whether that's something that you see as like a potential avenue in the future, whether that's hopeful.
Yeah, I mean, if you look, and you probably are familiar with it, there are so many different approaches, I think, that are being taken to advance this notion of animal rights and law. I think, there's the Non-Human Rights Project in the United States that's doing some really interesting work around, habeas corpus litigation and trying to free animals from unlawful captivity. I would say, for me personally, the thing that motivates me the most and excites me the most is the rights of nature trajectory, because that's really, I think, a trend that's growing, and there's so much momentum there around the world. And a lot of the rights of nature discourse and the agreements that are being made and the litigation, a lot of it really focuses on ecosystems and the rivers or lakes. But we have seen in South America in particular some court decisions taking rights of nature and agreeing that if the species has rights, then the individual members of that species also have rights. So I think that that's a really exciting path. It might not lead us exactly to animal rights overnight, but it does seem like it is a great way forward in kind of shifting this notion that only humans can be rights holders.
Well, I had said I had another question, but I've now forgotten it. So apologies for that. But I think this is a good time to draw things to a close. And so once again, we would just like to thank Kaitlyn very much for sharing her knowledge and expertise with us in this exciting story around protection of farmed animals. So thank you so much, Kaitlyn.
Thanks very much.